Ladies and gentlemen, a very good evening to all. My name is Anindita Dasgupta, and I'm the head of School of Liberal Arts and Sciences at Taylor's University, Malaysia. So I hope everyone is keeping safe and healthy amidst the ongoing pandemic. I'm deeply honored to be here today in the presence of fellow scholars, distinguished participants, practitioners, and students. And on behalf of the organizers, it is my honor and pleasure to welcome you this evening to the launch of the Malaysian Politics and Public Issues, or MPPI, series of talks. Now, the MPPI series of talks is an initiative by Zubedy's Unity and Harmony Mediators Movement, also known as Mediators, and Taylor's School of Liberal Arts and Sciences, Bachelor of Social Science, to educate, discuss, and promote the exchange of ideas on the nation's politics and public issues. So, ladies and gentlemen, in March this year, Taylor's University launched 2 new degrees in social sciences, one with a specialization in international relations, and the other in social innovation and change. Now, at Taylor's University, we believe that as a nation progresses and society continues to be more educated, Malaysia needs philosophers, advocates, artists, poets, innovators, people who can understand and analyze social needs and challenges, people who are creative, learned, and possess critical thinking and research skills. And one of the flagship modules in this program is titled Malaysian Politics and Public Issues, one that I'm very proud to share, that will be led by none other than Anas Zubedy. My colleague, Ms. No Ainif Omar, is the module leader, and Ms. Fadila Raihan Lokman is the co-instructor of this module. Now, ladies and gentlemen, our team led by Anas Zubedy decided to use a new way of teaching this module, that is, through a series of public talks and forums by distinguished speakers and thought leaders who have a deep understanding of the foundation of this nation, as well as those who have themselves been the architects of the idea of Malaysia. The goal is to provide the foundation and framework by experts in the subject through well thought out talks, and also create a platform for dialogue, discourse, debates via public forums. Now, these talks will be used as texts or learning resources for our students who, as future leaders, will have the opportunity to learn about this nation's history. Literature states that debates and dialogues move students beyond the rote learning of facts, theories, and techniques, and provide an opportunity of actively integrating and applying knowledge under an array of situations and circumstances in a spirit of mutual respect. I would like to thank Dr. Lloyd Tekman and Datin Chong Kwee Kee for making the time to be with us today, this evening. Thank you so much. Today, ladies and gentlemen, we are honored to have with us our inaugural speaker, Emeritus Professor Dr.Shad Salim Faruqi, Tunku Abdul Rahman Chair, Professor of Constitutional Law, University of Malaya, and the session will be moderated by none other than Anas Zubedy himself. Anas Zubedy is the Managing Director of Zubedy M. Siti Riyad Berhad, a training company that focuses on soft skills and making people more productive. Zubedy has been promoting unity extensively for the last 3 decades. Anas Zubedy is a Senior Fellow of Human Resources Development Corporation. Anas is also, I'm proud to say, Adjunct Professor at Taylor's School of Liberal Arts and Sciences, and Director of Social Innovation and Change at the Bachelor of Social Science, Taylor's University. Thank you so much again, ladies and gentlemen. Anas, the floor is yours.
Thank you so much, Dr. Anin. I will just quickly share screen and go through review some of the background so that we can see a bigger picture. Yeah, this. Yeah, just quickly, the Malaysian Politics and Public Issues series of talks and forums is an initiative by Zubedy's Unity and Harmony Mediators Movement, or Mediators, in Taylor's School of Liberal Arts and Sciences to educate, discuss, and promote the exchange of ideas on the nation's politics and public issues. Yeah? The big background, the goal is to provide the basic foundation and framework by experts in the subject through well thought out talks, and also create a platform for dialogue, discourses, and debates via public forums. The series of talks and forums will cover key topics like the Malaysian Constitution, socio-political history, public policies, and specific topics like education, national culture, general elections, integration, and economics. Now, ultimately, we want to educate, discuss, and promote the exchange of ideas about Malaysian politics and public issues in a mature, rational, and justly balanced way. The final one is really important. I think there are many debates, especially in the social media and also what you call it in WhatsApp group, that we need to actually pool and make sure that we debate and discuss in a mature, rational, and justly balanced way. Now, there are many who sent in questions, so you will find that for today, we will only cover the question that's we cover on the first talk, because there will be a series of it. You may want to take a picture of this. Yeah. Today, we're going to handle the making of Malaysian Constitution. You notice the speaker will be Prof. Shad, and you can notice we have 7 other series coming, not counting the forums you're going to have. If you take a picture of this, you can actually, follow us the next every 2 weeks, every Thursday. We hope to actually run this series. Now, allow me to introduce with all honor, Emeritus Professor Datuk.Shad Salim Faruqi. He's a Malaysian legal scholar and professor of law, and is currently holding the Tunku Abdul Rahman Chair as Professor of Constitutional Law, University of Malaya. He's also the 4th holder of the Tun Hussein On Chair in International Studies at the Institute of Strategic International Studies, ISIS Malaysia, effective July until 2021. He has served University Technology Mara in Shah Alam, various capacities as head of Diploma of Law Program, Assistant Director, Assistant Vice Chancellor, and Legal Advisor. There's a lot more to write and say about Prof. Shad. Just quickly, I'll end, but presently he also writes fortnightly in The Star, reflecting on the law. I suggest you may want to follow this fortnightly article because it really helps us keep in touch with what's happening, we call that, in terms of our constitution. Perhaps I share 3 of his books. One of my favorite is Document of Destiny. And last year, Prof. Shad just launched our constitution. Another book is launched by Zubedy some years ago called The Bedrock, Our Nation, Our Constitution. And with my honor to introduce and give the floor to Prof. Shad. Prof. Shad, may I pass you the floor.
Shafiq.
Prof, you are muted. You need to unmute yourself.
Right. Okay. Hello, Dr. Anindita, Anas Zubedy, all participants, especially those from Sabah Sarawak. Assalamualaikum warahmatullah. Apa khabar? Ni hao. Wanakam. Sat Sri Akal. I hope you're all keeping well. It's my great privilege and honor to be with you all. Now, my intention today, in the time permitted to me, is to give you a few words about what a constitution is, what its meaning and significance is, the making of the Malayan and later on the Malaysian Constitution, what I think was the spirit of moderation and tolerance that animated the drafting of our Constitution. Sadly, the gap between theory and reality that has emerged, and the role that you and I can play in bridging this gap and in making our Supreme Constitution the chart and compass and the sail and anchor of our national endeavors. May I now go on to my slides, trying to open them. Right. Let me begin by saying that constitutions are born to mark stages in progression towards self-government, to establish the foundations of a newly independent state, or to start afresh after a revolutionary or ideological upheaval. A constitution is a foundational law in the sense that it describes the manner in which the state is organized, government is carried on, and justice is administered. A constitution is like a political architect's master plan for the nation. It provides the legal foundation on which the structure of the state rests. A constitution is the supreme law of the land, the law of laws. In German, they say the Grundnorm, the basic law. It is of superior legal validity to all other laws. And whether these laws are passed by the federal parliament, the state assemblies, local authorities, or any regulations, decisions, actions taken by the executive, the Constitution is the litmus test of the validity of all actions. It provides the organizational structure of the executive, the legislature, the judiciary. It confers powers on them. And what's very important is that along with conferring powers, the Constitution also imposes limits on those powers. We have to please understand that powers must be accompanied by limits, at least in a democracy. Now, along with powers, there must be procedures as to how the power must be exercised. The Constitution defines institutional relationships between the various organs or institutions of the state. For example, the Conference of Rulers and the Yang di-Pertuan the Yang di-Pertuan and the Prime Minister and the Cabinet and Parliament, the Dewan Rakyat, Dewan Negara, the political executive and the public services. Then, very importantly, the Constitution seeks to protect human rights. The Constitution seeks to balance the might of the state with the rights of the citizens. Constitutions, most of them, are built on the assumption that rights are inherent. They are not given to us by the charity or generosity of the state. They come to us from a superior source. Now, the general scheme of the Malaysian Constitution is this, that first of all, the chapter on fundamental liberties, Articles 5 to 13, guarantees to all persons, in some cases all persons, in some cases all citizens, some fundamental liberties. At the same time, the Constitution recognizes that liberties can never be absolute. So it specifies the permissible limits that may be imposed by law on the fundamental liberty. Now, this is a very important point. Generally, people, the ordinary citizens, believe that those in power, parliament or the executive or the civil servants, the police, can impose any restrictions they feel are desirable or necessary. That's not correct. The restrictions that can be imposed are those which are permissible by the Constitution. For example, freedom of religion in Article 11 is subject to 3 restrictions: public order, national security, morality, and health. So the Constitution guarantees some human rights. It's special.
Can you mute yourself?
Can you mute it?
Gotcha.
Mute
I
it.
think- I think the host can
Should I
mute
invite your
all the
blanket
other
now?
people.
Yes, I'll go back to what I was saying. Let me go back to what I was saying. The Constitution guarantees some human rights. It specifies the enumerated permissible limits that may be imposed by law. And it provides remedies whenever rights are infringed. I'm sure you'll agree with me that rights without remedies are not of much use. As someone said beautifully, a right without a remedy is like a light that does not shine and a fire that does not glow. I'm trying to switch to the next. Yes, a constitution also provides ideals and values. At the philosophical level, a constitution supplies the fundamental or core values on which society is founded. In many constitutions, these values are contained in a stirring preamble. Sadly, the Malaysian constitution doesn't have a preamble, but the values are there: economic values, moral values, philosophical values, political values. A constitution reflects social realities. A constitution is not just a legal document. It is linked with the nation's history, politics, economics, culture, geography. It has as its backdrop the vast panorama of the past. And that's a point I wish to emphasize, that a constitution that wishes to endure, that wishes to last, must not depart too far from the values, the spirit, and the social and economic needs of the people. It must reflect to some extent the existentialist realities, the values, the vulnerabilities of the population. But at the same time, and herein lies the sublime challenge, a constitution must be idealistic, aspirational, and transformative. It must hitch itself to the stars. A constitution, it must balance stability with change. A constitution must contain within it seeds of change for a just new social order. Though it provides a blueprint for the nation, it's the political architect's master plan for the nation. A constitution is drafted in one age. It has to apply to the problems and challenges of another age. So it must balance continuity and stability with the need for social change. So all constitutions provide special, extraordinary, and difficult procedures for their amendment, so that the articles of the Constitution are not too easy to be amended, and at the same time, not too difficult to keep pace with the felt necessities of the times. So there has to be a balance between stability, certainty, to maintain the sacredness of the Constitution. At the same time, the Constitution must grow and change, but not like an ordinary law. It must grow and change under special, extraordinary procedures. A constitution in a divided society, a diverse society like Malaysia, it must promote unity in diversity. In a fragmented and ethnically divided society as Malaysia was in 57, and even more so in 63, and sadly remains till today, the constitution must seek to weld people together into one common nationality, to build bridges where walls exist. In a country where there are separate regions, states, or provinces that exhibit significant differences from the rest of the country, for example, Sabah, Sarawak are clearly different from the states of West Malaysia in their religious, racial, linguistic, cultural, and other characteristics. So if there are such significant differences, then the Constitution must recognize their uniqueness, accept legal pluralism, more than one type of legal system, and maintain unity in diversity by granting special autonomy to special regions like Sabah Sarawak, Quebec in Canada, Kashmir in India till 2019, Aceh in Indonesia, Mindanao in the Philippines. Now, how are constitutions drafted? I have to say this to you, there is no universal or standard way of drafting and later on ratifying, accepting, putting into effect the nation's document of destiny, as I like to call our Constitution. Much depends on the historical context and the constitutional model that is sought to be adopted. For example, if there is a military coup d'etat, a military takeover, they're not going to consult with the people to draft the Constitution. They'll appoint a special committee to draft it, and the martial law administrator will give the Constitution effect. But if the intention is to have a democratic constitution, then obviously some involvement of the representatives of the people will be adopted. For example, the US Constitution of 1787 to 1789 was drafted by James Madison, but it was ratified by the Philadelphia Convention of 13 states. The Indian Constitution was drafted by a Constituent Assembly, and actually it took 3 years from 1947 to 49 for this assembly, Constituent Assembly of the various provinces of India to draft the Constitution. The Philippines Constitution in the post-Marcos era was drafted by a special commission and ratified by the people at a referendum. The Malaysian Constitution, however, was quite different in its mode of drafting. It was drafted by a British appointed commission of 5 scholars, 2 from the UK, 1 each from India, Pakistan, and Australia. I'm sad to report that no Malayans were present on the Reid Commission. And sadly, no ladies were present on the Reid Commission. It consisted of 5 foreigners. Perhaps the justification for this was that they wanted a commission of outsiders who would not be motivated by prides, passions, race, religious, and other such factors, who could possibly be as objective as possible. By the way, the present Japanese Constitution was drafted by the American victors of World War II. So there is no universal way of drafting the Constitution, but one thing that can be said is that generally the drafting is done by a commission or committee of experts. That's the drafting part. Drafting cannot be done by an assembly of 350 people. But then there is a process of ratification, either by the elected legislature or by the people at a referendum. As I mentioned, in Malaysia, there was no referendum. However, there was a process of ratification. Now, sorry, I'm trying to, yes. Now let's look at the evolution of the federal constitution, the history of Malaya's emergence as a sovereign independent sovereign independent nation after centuries of colonial domination is a story with a wealth of perspectives. I'm afraid time won't permit. So I'll just emphasize 1 or 2 particular aspects of the Malaysian Constitution's drafting. I think the most important period, momentous years of Malay political history were the 11 years between 1946 and 1957. In 1946, the 9 Malay states, plus Malacca and Penang, were regrouped by the British masters as the Malayan Union, which would be a colony like the Straits settlements, totally under British control. The Malayan Union and the McMichael treaties deprived the Malay rulers of their sovereignty. The proposed citizenship provisions would have resulted in non-Malays becoming a majority in the country. All in all, the Malayan Union would have deprived Malays of their privileges, historical privileges, and abandoned the pre-war British policy of recognizing Malaya as a Malay country. For this reason, the Malays, under the leadership of UMNO leader Datuk On Jaafar, protested vehemently. In February 1948, the Malayan Union was formally dismantled, and the Federation of Malaya was established despite some protests from non-Malay organizations who saw the 1948 Federation as a return to the pre-war pro-Malay policy and the revival of the partnership between British imperialism and Malay feudalism, as many people criticized. Then in June 1948, the Communist Rebellion, styled the emergency, began. Thousands of lives were lost, and the sad experience of the insurgency resulted in drastic provisions of Articles 149 and 151 in our Constitution to deal with subversion and emergency in the Merdeka Constitution. In 1955, 2 years before Merdeka, elections were held to the Federal Legislative Council, which was partly elected and partly nominated. The alliance representing UMNO MC and MIC secured 51 out of 52 seats available. Armed with its massive mandate, the alliance demanded early independence. A Reid Commission was appointed by the British, and this commission consisted of Sir William Lord Reid, a British judge, Sir Ivor Jennings, a British expert on Commonwealth constitutional law, Sir William Mickell of Australia, Malik, Chief Justice, former High Court Chief Justice from India, and Justice Abdul Hamid of West Pakistan. The Commission's terms of reference were to make recommendations for a federal constitution with a parliamentary democracy, bicameral legislature, strong central government, safeguard for the position of the rulers, common nationality. It was going to be a citizen of Malaysia, not a citizen of Kelantan and citizen of Malaysia. No, common nationality. In the USA, by the way, you have a nationality of the state plus also of the United States. Safeguards for the special position of the Malays and the legitimate interests of other communities. The alliance drew up a 20-page memorandum for the Reid Commission. Half of the memorandum dealt with communal issues, by which I mean the relationship between the various races and the need to cater to Malaya's dazzling diversity. On most issues, the Reid Commission showed deference to the, I put that in quotation, the social contract or the negotiated settlement by the communities. The elites of the various communities got together and they decided to agree on some fundamental compromises. On most issues, the Reid Commission complied with this negotiated settlement. The word social contract are severely criticized by some, so maybe I should use the word negotiated settlement. By the way, the Commission held 118 public and private hearings. They went from town to town. They held 118 public and private hearings between June and October 56. It made recommendations on February 20th, 1957 and submitted a draft constitution. The draft provided for most of the features that were mentioned in the 20-point memorandum submitted by the alliance. Some of the Commission's proposals, however, caused consternation within various sections of the political community. Among the controversial provisions were the following. Reid proposals on citizenship were criticized by Malays as so liberal, so generous, that the country would be populated by a substantial percentage of non-Malays. There was this underlying fear that a Malay country would be converted into a non-Malay majority. UMNO objected to the provisions permitting dual nationality. People could be a citizen of Malaya as well as of the UK. UMNO objected to that. UMNO rejected the proposal that Malay special position in Article 153 would be temporary for 15 years only. Many people say it's for 15 years. That was the proposal. That proposal was rejected by UMNO. UMNO was troubled that no official religion was prescribed at the federal level. In the 1957 draft by Reid Commission, there was no Article 3 that Islam is the religion of the Federation. The Malay Sultans were displeased that the role of the Conference of Rulers was merely symbolic. The conference was basically a constitutional, the conference was basically having a role of electing the Yang di Pertonagong every 5 years. It had no other role in the earlier draft. Later on, Article 38 gave to the conference many other roles. UMNO objected to restrictions on creation of new Malay reserves. And UMNO wanted to extend Malay reservations to Penang and Malacca, where they did not exist. The provisions permitting multilingualism in the legislative assemblies and in parliament was regarded as too liberal by UMNO. So, as a result of these objections by UMNO, a tripartite working party was appointed. The tripartite working party actually had 4 members from the alliance, 4 from the rulers, and 4 from the British. So that's why called tripartite. They met in London and they tried to work out compromises. The working party had held 23 meetings between February and April 57 and made significant amendments to the Reid proposal. So those of you who know of the Reid Commission should please understand that the Reid Commission proposal, though beautiful in many other respects, was significantly amended by the Tripartite Working Party. The 15-year time limit on Malay special position was removed. Malay privileges were made an integral and entrenched part of the constitution. Islam was adopted as the religion of the Federation, but with freedom to all other communities to practice their own faiths in peace and harmony. However, documents clearly indicate that there was a clear agreement among the working party members that despite the adoption of Islam as the religion of the Federation, the country was not meant to be a theocratic or Islamic state. It was meant to be a secular state. That was the intention in 1957. The role and function of the Majlis Raja Raja was enhanced. The permission to use Tamil and Chinese in the legislatures was replaced with the provision that these ethnic languages, vernacular languages, could be used for non-official purposes, and their teaching and learning would be allowed for non-official purposes. At the end of the working party negotiations, some issues remained unresolved. Among them were UMNO's desire to extend Malay reservation law to Penang and Malacca. There was this problem of dual citizenship and the manner of appointing the first governors of Malacca and Penang. The dual citizenship problem was resolved by giving a period within which those holding dual citizenship would be allowed to choose one or the other. So there was a cooling off period allowed. All in all, changes made by the Working Party augmented, strengthened the indigenous Malay Muslim features of the Constitution. But this is what I wish to emphasize to all of you. There still was in the basic charter enough for everyone to relish and to cherish. Malay's special position was balanced by safeguards for other communities. The spirit that animated the Constitution was one of tolerance, compassion, and compromise. Now, I know I'll be running out of time, but may I please have about 10 more minutes, Anas?
Go ahead. Yeah, please go
Right.
ahead. Yeah.
Let me point out to you this delicate balance that was sought to be achieved. As I mentioned, every constitution must take note of some indigenous features. Those of you who study other constitutions will know that in every constitution, indigenous features are present. Some of the indigenous features are undemocratic, are purely historical. For example, in the United Kingdom, though there is no written constitution, nevertheless, the constitutional laws that exist at one time used to allow the judges of the highest court to also be members of the upper house of legislature. So that was quite remarkable that the highest court was also actually linked with the upper house. Very, very unusual and undesirable provision. Okay, so let me just quickly mention Malay features that were adopted were Malay Sultanate, Islam, special position of Malays, Malay reserves, Bahasa Melayu as the national language, customary laws of the Malays, weightage for rural areas at election time, legal restrictions on preaching of other faith to Muslims. These were the indigenous Malay Muslim features. But let's look at the features suitable for a multiracial and multi-religious society. Citizenship was granted to all persons, irrespective of race or religion. At the stroke of midnight on August 31, 1957, 1.2 million non-Malays were given citizenship. Now, this was quite remarkable because at that time, the overall population of the country was only about 6 million. The electoral process allows everyone, irrespective of race, religion, gender, or region, to seek election and to vote. Fundamental rights, Articles 5 to 13, with some exceptions here and there, are available in some cases to all citizens, in other cases to all persons, including non-citizens. For example, freedom of religion to all persons. Membership of the judiciary, the cabinet, the parliament, the public services are available to everyone, irrespective of race or religion. All this talk on us that we have heard, that the Chief Justice, that the Prime Minister, that the Chief Secretary cannot be a non-Malay, this is all political talk. There is nothing in the Perlembagan except for the Yang di Pertuanagong and the Sultans, who must be Malays and Muslims. At the federal level, no other office is reserved for any particular race or religion. The oath, for example, that the Prime Minister takes, or that the judges take, or that the civil servants take, that oath that they take has no religious element. The oath is loyalty to the country, to the Constitution. All right, then this will surprise many of you. Article 153 on the special position of the Malays and the natives of Sabah Sarawak since 1963. Article 153 is subject to Article 136. And what is Article 136? Article 136 says, in the public services, there shall be no discrimination on grounds of race. So now, how do we balance 153, which says reservations and quotas are allowed, and 136, which says no discrimination on grounds of race? I don't have to answer that question. Tun Sufyan, a former Lord President, answered that question adequately. He said at entry point, quotas and reservations are permitted. But once you are in the public service, there shall be no discrimination on grounds of race. That's what the Perlembagan says. Now, of course, there is a gap between theory and reality. Primary and secondary education is available to all, irrespective of race or religion. During an emergency, rights like citizenship, religion, everyone's citizenship, and language, everyone's language, cannot be suspended even during an emergency. Article 3, Clause 1, Islam as the religion of the Federation. It says in Article 3, Clause 4, nothing in this article derogates from any other provision of the Constitution. So though Islam is the religion of the Federation, nothing in Article 3 takes away, cancels out any other right or institution or law or procedure created elsewhere in the Constitution. Article 153 is not only about the special position of the Malays and the natives of Sabah Sarawak. It also says, and the legitimate interests of other communities. The Yang di Pertuan Agong has a duty to protect the legitimate interest of other communities. The quotas and reservations that he makes must be as may be necessary. The words used are reservation of such proportion as he may deem reasonable. So the words used are reasonable, proportion, necessary. There is a lot of scope in Article 153's interpretation for making 153 needs-based rather than race-based. In 1963, Sabah Sarawak were given a very special position in matters of lawmaking power, in matters of executive power, in matters of judicial power. For example, they have their own native courts, and in financial matters. I'm afraid that that is a huge topic, and maybe, Anas, we can arrange a separate session of federalism, especially Sabah Sarawak's rights. Bahasa Melayu is available, is the national language for official purposes. But for non-official purposes, there is a right to use, to teach, to learn. The Education Act says if 15 kids in a school request for a language to be taught, the school has a duty to supply a teacher, make reasonable efforts to supply a teacher. 15 kids asking for a language to be taught. And by the way, 152 says government has a right to preserve and sustain vernacular languages. That's why actually the Education Act allows vernacular schools to exist. Article 89 on Malay reserves. That's my last point on this balance. Article 89 on Malay reserve says no non-Malay land shall be converted to a Malay reserve. Article 89 on Malay reserve also says if a certain amount of land is reserved for Malay reserve, an equivalent amount shall be made available for general alienation. So all in all, actually, the spirit of the Constitution was one of give and take. The spirit of the Constitution was to build a mosaic and not a melting pot. That was the Constitution in 1957. Now this Constitution was then ratified by the Federal Legislative Council at the federal level, assemblies of the Malay states, the United Kingdom Parliament, and the British Crown. But no referendum was held. And I'm sorry to report to you that we also don't have a preamble whereby we, the people of Malaya or Malaysia, in order to secure liberty and democracy, do hereby give ourselves this Constitution. At the stroke of midnight on August 31, 1957, at Stadium Merdeka, the Duke of Gloucester, acting on behalf of the British Queen, handed over to Tunku Abdul Rahman Putra Al-Haj the constitutional document signifying the independence of the Federation of Malaya. with the cries of Merdeka, Merdeka, Merdeka 7 times. It wasn't 3 times actually, 7 times. Malaysia's appointment destiny had begun. Now, sorry, from Malaya to Malaysia, here again, time doesn't permit the rich history and diversity of the Borneo territories. But what I want to point out is this, that in April 1962, a joint British-Malayan commission known as the Cobbold Commission investigated the proposal and reported that the people of the Borneo states wished to join Malaya and that the new federation would be in the best interest of North Borneo and Sarawak. Now, many people say, oh, the Cobbold Commission was very unfair, didn't listen to enough people, it was an elitist one, it only heard a very small percentage of the population. Maybe so, maybe so. I think these are historical issues on which differences exist. But there were other historical events like the resolution of the Malaysia Solidarity Consultative Committee 61, resolution of the Legislative Council of North Borneo, which Sabah was called last time, the 20-point manifesto of the Sabah Alliance, 19-point manifesto of Sarawak. Sorry. Then there was an Inter Governmental Committee. The report of the Cobbold Commission led to the establishment of the IGC. Then after that, general elections were held in North Borneo, that is Sabah, and also in Sarawak. And the proposal to form Malaysia won the support of the electorate. I'm fully aware that many people of Sabah Sarawak are saying all these were fraudulent, they were not genuine. Maybe so, but these events did take place. However, the Philippines and Indonesia opposed the formation of the new federation. And I'm sure you're all aware that Manila till today has not given up its claim to Sabah. And as you all know, Indonesia resorted to that undeclared war, the confrontation. Also, there was internal opposition from the government of Kelantan. But I'm coming to that. There was a UN mission which spent 3 weeks in Borneo, reported that the Malaysia proposal had the backing of these territories. Singapore also was part of all this negotiation for a good reason. Singapore was worried about communism spread, and they felt that the independence of Singapore could be secured only if it joined the Federation of Malaya. Brunei, initially enthusiastic, but it backed out because of 2 issues primarily. One was oil reserves, Brunei's right to oil reserves, something that actually is also now an issue between West Malaysia and Sabah Sarawak. And then the precedence of the Sultan of Brunei. Generally, the way it works in the Conference of Rulers, there is a precedence. The earlier you became a sultan, the higher up you are in the hierarchy. But since Brunei would have come last of all, would have been last on the list, and the Sultan of Brunei didn't agree to that. Then there was a Malaysia Act that was passed in 1963. Now, government of Kelantan objected on the ground that the Constitution of Malaya was amended to make Malaya into Malaysia by adding 3 new states without the consent of Kelantan. Kelantan argued Article 159, which deals with amendments, cannot be done without the consent of Kelantan. But the court rejected Kelantan's case and said Article 159 nowhere requires the consent of the states of Malaya to making an amendment to the Constitution. But let me quickly add, since 1963, if there is any amendment to the Constitution of Malaysia which adversely affects Sabah Sarawak, then the consent of the governors of Sabah Sarawak has to be obtained. I'm approaching the end. So the Federation of Malaya transformed to the new and enlarged Federation of 14 states. Sadly, um, um, 2 years down the road, Singapore and Malaya could not work together, and Singapore was allowed to leave. Many people say Singapore was expelled. Some people say Singapore was allowed to leave. Some even say Singapore seceded. They left. I'm sorry, no one has a right to leave. The Constitution doesn't allow anyone to secede. Singapore did not secede all by itself unilaterally. The Perlembagan was significantly amended to allow Singapore to be excluded from the Federation of Malaysia. Now, as I contemplate the past, it is quite clear that our forefathers intended to adopt a mosaic and not a melting pot for our constitution. In Malaya, the special position of the Malays was balanced by the guarantees for the non-Malays. In relation to Sabah and Sarawak, their distinctiveness was recognized, and rightly so, and considerable autonomy was conferred. Sadly, I have to concede a wide gap exists between theory and reality. To bridge this gap, one important task is to improve constitutional literacy. I think what Anas is doing, what Taylor's is doing now, actually is part of the broader task and the challenge of improving constitutional literacy. Thank you very much. Assalamu alaikum.
Thank you. Thank you so much, Prof. Shad. Yeah. And let me just, maybe Prof. Shad can. Thank you so much, Prof. Shad. Yeah. Thank you for trying to pack a very large subject within 45 minutes to 15 minutes.
Yeah.
I noticed you are trying very hard to rush. I hope that I did not force you to do this in too short a time. It has been a fantastic, what I call, very detailed for me. A lot of things in your presentation helped me see things that I may have missed in the past, and I'm sure for many of us too. Now open for questions, but first, there are already questions sent much earlier. I will first share this question. Should we have more time, and then we will continue with other questions. You don't mind, Prof. Shad, maybe we can extend until 9:30 rather than 9:15, yeah? Kalau boleh. Yeah. Let me just share the questions. No, now, just again, for those of you who have sent questions and I'm not putting it up, is because the questions are more relevant for future series. Please join us and resend the question. But what I'm going to do today is I'm choosing questions which are more relevant to the current topic. Yeah. The first question, Prof. Shad, we'll take one question at a time. The first question is the most recurring question that we got, and you have mentioned part of it earlier, but just quickly and more precisely, let's deal with this. Is Malaysia a secular or an Islamic country under the Malaysian Constitution? So this is the most recurring question. Usually there are 4 or 5 people asking this question. Prof. Shad?
Right, thank you. Actually, the question is built on a fundamental presumption that things must be black or white, dichotomy. So either you are secular or you are theocratic. The reality is that there may be lots of gray shades in between. That's one. Secondly, the question is riddled with this problem of semantics, the meaning of words. What do you mean by secular? What do you mean by theocratic or Islamic? What do you mean by democracy or authoritarianism, capitalism or socialism? So much depends on what meaning you have chosen for secularism and theocracy. My personal view is this: that the Malaysian constitution is neither theocratic nor is it full-fledged secular. Why do I say that? It is not theocratic because Article 4, Clause 1 says, this constitution is the supreme law of the federation. And any law passed after Merdeka Day, which is inconsistent with this constitution, shall, to the extent of the inconsistency, be void. Many years ago, Anas, there was a case, Che Omar Che So versus public prosecutor. Che Omar Che So was prosecuted under a drug law for which there is a mandatory death sentence and a presumption of guilt if a certain amount of drugs are found. So a very clever argument by the lawyers for Che Omar Che So was that the drug law makes un-Islamic presumption. In Islamic criminal law, Islamic criminal process, there is no presumption of guilt. Everyone is innocent till proven guilty. In Islamic criminal law, there is no death penalty for drug trafficking. So the argument is this law is un-Islamic, and because Islam is the religion of the federation, therefore the law is unconstitutional. Tun Saleh Abbas, the renowned judge and a very well-known Muslim adherent to Islam, he presided over the court and said that the constitution is supreme. Article 3, Clause 1 on Islam is not making Islam the basic law of the land. Islam is not the litmus test of validity. A law is valid or invalid by reference to the Perlembagaan, not by reference to Islamic principles. So Article 4 is quite clear that the constitution is supreme. Article 3, I mentioned to you, Islam is the religion of the federation, is immediately accompanied by Article 3, Clause 4. Nothing in this article derogates from any other provision of the constitution. On the other hand, I have to point out that to say Malaysia is a secular state would require a willing suspension of disbelief. If someone says to me, Malaysia is a secular state, I'll say, hey, are you joking with me? People can be arrested for khalwat just by being in a room together and taken to court and fined or maybe even jailed. You can be arrested for not fasting. You can be arrested for not saying your Friday prayers. You don't do that in a secular state. You are compulsorily subject to the Islamic law in enumerated areas, about 25 or so enumerated areas. So surely in the case of Muslims, the 61% of the population that is Muslim, Malaysia is clearly not a full-fledged secular state. Much depends on how you define secular. If by secular means a supreme constitution, then we are secular. If by secular means no religious values or doctrines are imposed on the people by the government, then clearly we are not secular, because 61.5% of the population is compulsorily subject to the Sharia in 25 or so enumerated areas. So my answer would be, I'm sorry I can't adopt this or that. I think we are a hybrid. We are a plural state. We are a constitutional state with pluralism, legal pluralism. There are features of both. And I'm not ashamed of that at all.
Thank you. Thank you so much. This is a very good answer, very balanced and very real. Yeah, it's very real. Yeah, I would like to share the second question. Yeah. The second question is from Johnson Chong. Yeah. Do you think the federal constitution, as it stands today, enables Malaysians of all races and religions to unite and build a nation based on the principles of equality and justice?
I think that's a lovely question, Johnson. And all that I can say is this. studying the 183 articles and the 13 schedules and the thousands of cases that have emerged from 1957 up to now, about 64 years. There are seeds of both. The Constitution is in words. Words are like an amoeba. You know, the small organism amoeba changes shape. Words are capable of many, many meanings. So much depends now, actually, Johnson, on the interpreters of the Constitution, the judges, the civil servants, the politicians, the people in the Pejabat Pegawai Negara, the AG's office. I tried to point out to you earlier that, in my view, the Constitution contains elements to accommodate our dazzling diversity. I think the Constitution was a balanced document. It recognized the indigenous features of the Nusantara, of the Malay majority. At the same time, it recognized many of the needs of the non-Malay population. It's now up to you and me to interpret the Constitution in a way. There are currents and cross currents. May I give you one example, Johnson? This is from the, I think it is from the mid-80s. There was a fellow in Kelantan, a Malay fellow in Kelantan, who had converted to Christianity and was trying to convert others to Christianity. He was arrested under the ISA, Internal Security Act. His lawyers applied to the High Court for the writ order of habeas corpus, and he won the case. In the 80s, the court said, you cannot arrest a person under the ISA. His name was Jamaluddin Osman, later on called Joshua Jamaluddin. Jamaluddin Osman won the case. The court said, you can't arrest a man under the Internal Security Act just because he converted from Islam to another religion. That was the spirit of the Constitution in the mid-80s. Later on, however, Johnson, there have been cases, especially involving unilateral conversion of children from Hinduism, let us say, to Islam. For example, the famous case of Indira Gandhi, anak perempuan Muthu, and the poor lady in 2009, her mu'allaf husband, the husband who had converted to Islam, he went off with one of the children, converted the child, and the High Court and the Court of Appeal sided with the husband and said, yes, you can convert. One parent can decide on the conversion of the child. In 2019, I think, or was it late 2018 or early 2019, the federal court gave a beautiful decision and said, no, a child cannot be converted from one faith to another without the consent of both parents. And I personally support that decision, because both parents should have equal rights to the child. Should not be just one parent unilaterally making that decision. So, Johnson, there are currents and cross currents. It depends on which current we want to swim in. I have to say this, here and everywhere, it's not the law that makes us free. It's we that make the law free. By which I mean, it's we who, with our interpretation, who with our advocacy, who with our commitment, see the law in a way that it would be more equitable and more just. So I congratulate the judiciary in the Indira Gandhi case of 2019, 2019, whereby they said you cannot just convert a child unilaterally. However, Johnson, the sad part is, though Indira Gandhi won the court case, she hasn't got back her child yet. The police have been unable to enforce the court judgment. So Indira Gandhi still weeps for her lost child. So I really cannot answer your question except to say the Constitution has enough in it for a just, equitable, fair society. It's a matter of interpretation by the judges, but not only the judges. Let's remember this. 90% of conflicts don't end up in the courts. They either end up in the civil service or with the police or with the local authorities. So it's public servants. It's you and I. It's teachers in the school. Is a teacher a racist, religiously bigoted teacher who may order kids of one religion to say, hey, you cannot eat food during Bulan Puasa in the hall there. You must go to the toilet and have your meal there. If there is a teacher like that, he or she is not following the spirit of the Constitution. So actually it's up to us. The Constitution, however, is a balanced document. Though of course it can grow and change in accordance with the needs of the times. Thank you.
Thank you, Prof. I will just go straight to the third question. Yeah? Now, this is by Mary Madeline. How did the preservation of the Malay rights and privileges get carved into stone? I think you covered it a little bit earlier, but let's see whether we can nail this. It is written into the Constitution. Is it written in the Constitution that it is the Tuan Agong's prerogative to ensure rights and privileges of Malays? Is it carved in stone? I think here the question is it carved in stone? I mean, that's the spirit of this question.
And that's a beautiful phrase, carved in stone.
Is it carved in stone? Yeah.
Yeah. Well, to me, carved in stone would mean it's unamendable, cannot be taken away like the 10 Commandments or like a holy book. The Constitution is amendable. If one were to want to amend this part, if a future government wants to amend, then it can be amended. It will require a 2/3 majority in both houses, plus the consent of the Conference of Rulers. And don't forget, 153 deals also with Sabah Sarawak. It will require the consent of the governors of the two Borneo states. But it can be amended. Someone will say that's mere theory. It will never be amended. Well, maybe so, but don't forget, rights of the rulers were amended in 1983, 1984, 1993, 1994. So it is amendable. However, in addition to that, what I want to say this to my learned colleague, Mary Magdalene, actually, if one were to read Article 153, not just with the head, but with the heart, with a sense of justice and equity. Within Article 153, Anas, there are words like
reasonable.
That the Constitution, that the Yang di Pertonagong must also safeguard the legitimate interest of other communities. There are words like the quotas that he makes must be as may be necessary, as may be necessary. So if it's not necessary, then there is no need to make the quota. Reservation of such proportion, in other words, no monopoly, proportion, as he may deem reasonable. Reasonableness, Mary, is a judicially defined term in administrative law. So I think there is scope, as I was saying earlier, for Article 153 to be gradually evolve in such a way as to make it need-based, and to cater to not only the situation between different races, but to cater to the situation within a race, to cater to the disparities within the Malays and within the Chinese and Indians and the major groups of Sabah Sarawak. I think that's an unmet challenge. And I hope and pray that Article 153 will not be politicized the way it has been, will be interpreted in such a way as to be an article promoting social engineering, promoting social restructuring, promoting justice and equity, rather than a case of superiority of one over the other. By the way, in Article 153, the word used is not privilege. The word used is special position. Kedudukan istimewa. It is not, the word privilege is not used. The word right is not used. The word is special position.
Thank you for a very precise and very interesting answer, Prof. I will go straight to the next one. This is by Aaron Dinesh. What is the difference between the religion of the Federation and official religion? And is it true the Malay rulers at the time did not want Islam to be the official religion of the country?
Yeah, as to the first question, what's the difference between official religion and religion of the Federation? I'll confess to you, I don't want to cheat you. I don't know. I don't know the answer. But the commentators say this: official religion may have a wider connotation that it must be used all the time, whereas religion in the Federation basically means this is the religion by which the country identifies itself. But don't just look at the word Islam is the religion of the Federation. Look at the accompanying clause, but all other religions may be practiced in peace and harmony. So the interpretation of many scholars is that the way the Perlembagaan is drafted, it does not imply that there is only one religion in this country. I just want to mention this to you, Anas. In some countries, and I don't mean to pass adverse comment about them, in some countries, the list of religions is specified. Indonesia is such an example. In Malaysia, there is no official list of religions. Islam is the religion of the Federation, and all other religions may be practiced in peace and harmony. So clearly, this country recognizes multiplicity of religions, pluralism, and diversity in this matter. Perhaps the intention was to avoid the kind of language of Article 152, Anas. 152 is Bahasa Melayu, as the Bahasa Kebangsaan shall be used for all official purposes. I don't think they wanted to use that kind of language. So I'm sorry, I don't really know, but that's my view. As to the second one, yes, you are entirely correct. Initially, the Malay sultans did not want Islam to be adopted at the federal level because they thought that would undermine their position as heads of the religion of Islam in their own regions. However, UMNO objected to that, and UMNO was strongly supported by one judge, Justice Hamid from Pakistan, who said, what's wrong with having an official religion? Justice Hamid pointed out that at that time, 1957, there were about 25 other countries in the world that had an official religion. Why not Malaysia? My study indicates that at this particular moment, about 20% of the countries of the world, so 20% of about 200, that would make about 45 countries of the world actually have an official religion. So ultimately, UMNO and Justice Hamid prevailed, and Islam was adopted at the
Federal.
as the religion of the federation. But it is quite clear also in the federal constitution that the Malay sultans retain their position as the head of their religion, as the head of the religion of Islam in their territories. But in 7 territories, the Yang di-Pertonagong is the head of the religion of Islam. At the Wilayah Persekutuan, Labuan, Putrajaya, Penang, Malacca, Sabah, Sarawak, sorry, one more, 8, and in his own country, in his own state,
Yeah.
So the Yang di-Pertonagong is the head of the religion of Islam in 7 territories plus his own, so 8 territories. In the rest, the sultans actually have the power over Islamic matters. And I don't know if you'll remember many years ago, and I don't mean this as a criticism, but as an example. Many years ago, in the rest of the country, Hari Raya was declared on a particular day.
Right.
But in one particular state, the Sultan said, no, in my state, Hari Raya shall be the next day. And he prevailed because he's head of the religion of Islam in his state. So I don't think in 1957 the intention was to truncate the powers of the Sultan. However, what has happened lately is this, that some federal agencies funded by the federal government are asserting themselves so much that they are in some respects actually trespassing on the areas which many states would like to have as part of their jurisdiction. For example, halal, what is halal and what is not halal, has become a federal agency matter. Many states would love to have control over this because it's a source of income.
Yes. Yeah.
Okay.
Thank you. Yeah. Let me go to the next one. Now, this is a question not about the making constitution. It says, how can we make everybody, by Nur Aida Mokhtar, how can we make everybody be aware of their rights under the constitution? I thought this is a good question to ask you.
Aida, this will be a lifelong quest. And it's a quest in which all of us have a role to play. In almost all countries of the world, people don't really know their laws. They have vague notions. As I was saying earlier, the constitution is a matter of interpretation, and depending on the prejudices of the parents, because in the home, actually, the prejudices begin. In the classroom, these prejudices are implanted. So I'm just giving an example. When Tommy Thomas was appointed, I heard from so many people, hey, Attorney General cannot be a non-Malay. Because some people even went to the extent of saying, hey, the oath of the Attorney General requires him to swear on the Quran. So I told myself, that's not the copy of the Constitution I have at home. My Constitution doesn't say that. But this is what actually some politicians were saying. So it's a big challenge. My suggestion would be this: the Constitution should be taught in schools, especially a little bit in primary, in secondary schools. It should be taught as a compulsory subject in universities. A more elaborate and realistic version of the Constitution should be taught to the police and to the civil servants at Intan and at the Maktab Police Charas. At the moment, very, very selective. I want to mention this to you very frankly, not with any bitterness. In 1998, 99, when Suhakam got going, Suhakam set up a small committee to promote constitutional literacy. I had the privilege of being on that committee. We drafted a proposal to introduce constitutional literacy in the schools. You know what we were told? No need. We already teach the Constitution. 2 or 3 years ago, the Constitutional Literacy Initiative of the University of Malaya again approached the ministry for this purpose. And the ministry came out with beautiful PowerPoint presentation with saying, see, we already teach, there is no need. So we said, can you show us what do you teach? And you know what we found out? Basically, they teach about the Malay Sultans, they teach about Malay special position, they teach about Islam. They don't teach about human rights, they don't teach about Sabah Sarawak, they don't teach the history of the evolution of the Constitution. So it's a very politically colored, selective, doctored version of the constitutional history that is taught in our schools. So either in answer to your question, I think we need constitutional literacy. And my hope is that programs like what Zubedy Taylor is doing, and my hope is this, that a book like this, a small book on the Constitution. By the way, by the end of this year, this book is also coming out in Bahasa Melayu, inshallah.
This
God
is
willing.
our constitution, the one at last year's one, yeah? Yeah.
Yes, yes, it's coming out in BM. I hope that with constitutional literacy, they will one day develop constitutional patriotism. In other words, a respect for the Constitution as the sail and anchor and the chart and compass of our national endeavors. I have to say this to you with some sadness. Within the civil service, within the government, within the universities, the attitude is dasar kementerian, dasar kerajaan, dasar cabinet. Policy overrides everything else. No, sir, it cannot. Any dasar, any decision, any law must be under the Constitution, not against or above the Constitution. But the training of the civil servants is this. If the decision is made, if the policy is adopted, forget the Constitution. And that should not be so. So we have to disabuse people of some of these prejudices, that the Constitution applies only when the government wants it to apply. The Constitution applies to Parliament, it applies to the executive, it applies to the judiciary, it applies to all of us. It applies where it hurts, it applies where it helps. What do I mean where it hurts? It applies even where it may impinge on your right. It applies, and it applies where it helps. So you have to take it with its good, you have to take it with its bad, and you cannot say, I want to be selective. I like only that part which I like and which favors me. That part that favors somebody else, the other, I don't like. Now, you cannot do that. The Constitution must be read as a whole, W-H-O-L-E, holistically. Its glittering generalities must be read in the light of all other provisions of the Constitution.
Thank you so much. Just because we have to end soon, but I got one final question. This is from me. Yeah. Can you share with us, what do you think of the men and the people that work towards the Constitution? People like Tunku, when they were working towards the Constitution, what kind of spirit did they carry? Maybe a short one. Yeah.
Yeah, sure. Actually, Anas Tunku's role was a very majestic one, very admirable one, and sadly, it has not been given due credit, though there are some books on it, but those books are not prescribed in the universities. Tunku was in negotiations with many parties. He was in negotiation with the extreme right factions within UMNO, extreme right factions within MCA, MIC. He was in negotiation with the rulers. He was in negotiation with the British. So there was actually negotiations with many, many parties. And basically, he tried to walk the middle path. And I must give credit to many others the forefathers of the Constitution in 1957 from MCA, from MIC. Tunku was not the only one. I think all the forefathers of the Constitution, and their name list would be quite lengthy. In 1963, the Sabah Sarawak leaders, I think they all worked together to produce what I personally think was a document that catered to our dazzling diversity. It did not cater just to one particular religion or one particular community. What has happened, sadly, is this, Anas, that we have regressed. For the first few decades, up to the 80s, Malaysia was regarded by many countries of Asia, Africa as an exemplar of a country where democracy, development, religion and secularism, economic development, as well as social change can take place. You look at the way, for example, in Zimbabwe, former Rhodesia, in Kenya, in Uganda, social justice was sought to be achieved. Compulsory expropriation of property. That was not done in this country. So I think we tried the middle path. Sadly, we have regressed, partly because of parents' failure in the home to instill the right values. Teachers, university lecturers, I think we've all failed. As I was saying earlier, the hope now lies actually with us. It's not the law that will make us free. It's we that will make the law free by advocating right values. Thank you very much.
Thank you so much, Prof. Shad. Yeah, this has been a very enlightening and very informative evening. I am so happy, and I'm sure many others too are very happy to know that we'll be meeting you more often. Yeah, I would like to.
I hope so.
Yeah, let's inshallah. Yeah, let me just quickly show the list. Yeah, the next 2 weeks we will have Dr. Chandra. Well, let me just Dr. Chandra, the making of Rukun Negara, and then we'll meet again with Prof. Shad, understanding the Malaysian Constitution. So for those of us who have gone through today's program and want to ask more questions this time around to understand the Malaysian Constitution, I hope that you will join us next time. And just quickly, I would like to thank you again, Prof. Shad, and thank you my colleagues and friends in Taylors, and thank you all of you here who have with us who waited for 1.5 hours and listened to attentively. Thank you to Dr. Anin for giving me this chance to work with your team coming up with Malaysian politics and public issues. With that, thank you so much, everyone. Hope to see you again in 2 weeks' time. Prof. Shad, thank you so much.
Thank you very much.
All right.
Thank you then. Assalamualaikum.
Welcome, salam.
May peace be upon you all.